I'd like to introduce our two guest speakers today. Amanda Tyler is a professor of law at the University of California, Berkeley School of Law. She holds a degree in public policy with honors and distinction from Stanford University and a JD Magna Cum Laude from Harvard University School of Law. Professor Tyler served as a law clerk to the Honorable Guido Calabrese at the U.S. Court of Appeals for the Second Circuit and for the Honorable Ruth Bader Ginsburg at the Supreme Court of the United States. She also practiced as an associate with Sidley Austin in Washington, D.C., and is the author of one of our book topics of choice today, the Habeas Corpus in Wartime. Professor Pfander here is the there he goes. Professor of Law at the Northwestern Pritzker School of Law. Professor Pfander writes and teaches mainly in the area of federal jurisprudence, or in federal jurisdiction, particularly as it relates to Article 3 of the Constitution. His book, seen here, Constitutional Torts and the War on Terror from Oxford Press, was released last year. It's a valuable treatise on the area of Bivens litigation in wartime. Very curious to see what he's got to say about that. Again, I'd like to thank them both for being here. Format-wise, I'm just going to kind of let them both carry the conversation. They both have, what they kind of want to say about their books and about litigation in the future and going forward. So I would just, without further ado, just help me welcome them to John Marshall.
Thank you. We flipped a coin and I got to start. So first let me say thanks to the American Constitution Society, to Grant, to Joe, and to all the folks for putting this together. And a special thanks to Amanda for joining us. And thanks to all of you for coming here on the cusp of the 4th of July. The 4th of July got me to thinking a little bit about traditions and patriotism and the like. And it's sort of, as I think when I pledge allegiance to the flag, I always think about to the republic for which it stands, trying to figure out, what part of that republic I feel like pledging allegiance to these days. And one of the things that I have found, and I think it's reflected in the book, is that while there are many things about the early republic period and the founding era in our nation's history that we might raise questions about, there is something to say for the approach to government accountability and the rule of law that was incorporated into the law of the early republic. And so while we disenfranchised women and while we enslaved African Americans and we made improvement on a lot of those areas, we did have a very, in some ways, strict and formal approach to the enforcement of rights. And you can see that relatively strict, relatively formal approach reflected in both of the works that we're going to talk about today. My focus is on the use of the suit for damages as a way to ensure government accountability and the special role that the suit for damages plays today in that rule of law process. Amanda's book obviously is about the use of the writ of habeas corpus traditionally and more recently. And we both tell a story of decline, a story of erosion from a kind of 19th century strict or formal approach to the rule of law to a somewhat more open textured balancing approach that prizes national security and state secrets and the like, and has the tendency to avoid reaching the merits and the tendency to defer to the government's approach to the war on terror, to detention, to extraordinary rendition, to enhanced interrogation or torture as we know it. And so one of the questions that we will both be asking ourselves is it possible to recover a kind of 19th century approach to the enforcement of these rights that we all hold dear in the modern world, and is it possible to get back to that kind of approach to rights enforcement? And so we want to talk a little bit about our books, and we'll try to keep that relatively brief and leave lots of time for you guys to ask questions, and also to talk a little bit about recent developments. Since my book was published a year ago, the Ziegler and Abbasi decision came down, further sort of cementing a very restrictive approach to the recognition of rights to sue under the Bivens Doctrine for constitutional torts, for damages claims. And there have been developments in other areas that may be of interest to you. One of the really interesting cases, of course, is the Hernandez versus Mesa cross-border shooting case that is now back before the Supreme Court this year with a petition for certiorari filed, I think, quite recently, if I understand right. So that's the plan, and I'll just start with a brief summary of the findings in my book, and then turn it over to Amanda. The striking thing for me as I compared the 19th century approach to enforcement of rights and the modern approach was the difference in the judicial conception of the duty of the court. And so in the 19th century, the courts had a very narrow perception of their duty. They were to adjudicate the claim of right and to leave issues of emergency, crisis management, issues of national security. Those were all for the executive branch and for the Congress to manage, not for the courts to manage. The courts instead focused only on the question whether rights had been violated. And I ascribe this approach to the rule of law from the early Republic period to Madison, James Madison, whose fingerprints are all over it. But you also see it reflected in decisions by Chief Justice John Marshall, by Justice Story, by others of the period. And I can't resist reading to you just a brief snippet of a quote from a Justice Story opinion that appeared in the early 1800s. And he is here responding to a claim, very much like the claim that the government makes today, that you should defer to us because we're involved in these difficult questions of government management. We're dealing with extraterritorial issues. We're managing relations with other countries. And that's the reason why there should be deference to the actions of the government instead of enforcement of rights. And in this case, Justice Story decided in favor of rights enforcement and refused to give effect to the government's argument for deference. And here's what he said about the judicial duty. It may be fit and proper for the government in the exercise of the high discretion confided to the executive for great public purposes to act on a sudden emergency or to prevent an irreparable mischief by summary measures not found in the text of the laws. In other words, stuff happens and the executive has to respond. Such measures are properly matters of state, and if the responsibility is taken under justifiable circumstances, the legislature will doubtless apply a proper indemnity. But this court can only look to the questions whether the laws have been violated, and if they were, justice demands that the injured party should receive a suitable redress. So the courts adjudicate the claim. They enter a judgment if they find that the rights of the individual have been violated. And how do you protect the officer? How do you prevent the imposition of liability from unduly dissuading the officers to take appropriate steps in crisis situations? You provide them with indemnity. And that was a routine practice in the early Republic period. Again, a practice that James Madison was in some sense the architect of. So he put a mechanism in place for individual officers to seek indemnifying acts of Congress to pay the officer back for any money that the officer was required to pay to the injured individual. This had a couple of very nifty results. It protected the officer, so you didn't need a doctrine of qualified immunity. It overcame the doctrine of sovereign immunity because it resulted in the government's payment of the money, something that you couldn't enforce directly with a suit against the government. And it articulated norms. The courts would actually articulate the legal norm in question and determine whether rights had been violated. And so you had all of these sort of elements built into the relatively formalistic, relatively strict application of common law norms to determine the legality of government conduct. What do we see today? We see today instead a kind of balancing approach to everything that really prizes the concerns of national security and the idea of deference to the executive. So in modern cases, and you'll recognize the names, but many of the cases are described in the book, cases like Arar versus Ashcroft, the Canadian national who was subject to extraordinary rendition while passing through JFK Airport, transshipped to Syria, tortured for a period of time, and then ultimately released. Canadian government paid $10.5 million in reparations. Arar also sued in the courts of the United States. That was obviously for Canada's part in the extraordinary rendition. In the courts of the United States, Arar brought a suit against the responsible officials, and that suit was turned away on the basis that there was no right to sue under the Bivens Doctrine because it implicated national security and arose in a special kind of extraterritorial setting where there hadn't been any previous decisions made. And so Arar is left without any remedy in the courts of the United States, despite the kinds of behavior to which he was subject. The same thing happens to a guy named El Masri, who was taken in Macedonia, turned over to the CIA, transshipped to the Afghan salt pit, aptly named, for torture and questioning. The CIA actually got the wrong guy. One of the reasons that Gina Haspel was questioned at her confirmation hearings as the new CIA director is that she was very much involved in the El Masri conduct. Eventually, when the torture ran its course and they realized they had the wrong guy, they just kind of turned him loose, and he wandered back to Germany, where he was from, and a series of investigations ensued, and it was determined that he had been subject to this kind of mistreatment by the CIA. What happened in that case? The Fourth Circuit dismissed it because the litigation of the case would occasion the revelation of state secrets. And so given the state secrets privilege, you can't actually adjudicate these claims because even though everybody knew what happened to El Masri, there was something secret about it, and therefore the courts had to turn the case loose. I think this is very revealing because if you look at the mine run of cases, you get occasional adjudications and occasional awards of damages in cases that arise in settled areas. But if there's anything the least bit unusual or extraterritorial about the claim, if it's a claim against the FBI in Africa, if it's a claim against military treatment in Afghanistan, even when the victims are U.S. citizens, the federal courts are finding ways to turn these cases away, to push them away without ever reaching the merits. And so the criticism in the book is really that the federal courts have failed to do their job. They should be adjudicating these claims. They should be articulating norms so we can say what is torture, what is cruel and inhuman treatment, what is or is not legal about extraordinary rendition and waterboarding. And instead, the courts have failed to step up. The Supreme Court has responded by saying we don't really adjudicate issues of policy in the context of suits for damages. We only do it in suits for injunctive relief, suits for declaratory relief, or maybe in habeas proceedings. But the consequence of failing to adjudicate in damages claims is that you get no adjudication at all. Because you can't seek injunctive relief in the middle of a waterboarding session. You can't seek habeas corpus when you've been taken to the salt pit in Afghanistan. Those remedies fall out. The only remedy you have is the suit for damages. And if that remedy is denied, there will be no adjudication of claims of right. And that is pretty much the situation, I think, that the Ziegler and Abbasi case leaves us in. The book then goes on to suggest some solutions and cures that we might adopt, but I've talked long enough and I want to get Amanda involved. Yeah, please.
Question, maybe it's not related. Two things. One, there was a fellow that, I think in Spain, the fingerprints, somehow they identified him as one of the people that was involved in Spanish, whatever, and then he finally was in custody for 18 months, and I think he sued here, and he got like some millions of dollars. I'm not sure of his name. And
I don't know the case.
Pardon?
I don't know the
Where his
case.
fingerprints were identical to someone else's?
Well, they somehow, they misread it. They said it was him. He was somewhere in, they claimed he was in Spain. He wasn't there. He was locked up for 18 months or something like this. And the other question that I have is, it was the American Psychological Association or something. They came up with that finding that first that there was no torture, it was okay, and then it was kind of reversed. You know, what was that?
My knowledge of the particulars around the American Psychological Association's relationship to torture during the War on Terror is thin, but I do know that a couple of people with some standing as psychologists were involved with the CIA in the creation of these mechanisms of enhanced interrogation or torture or what have you. I understand that the association has disavowed the work of those psychologists, has subsequently. I don't know what politics unfolded during the course of the initial development of that program, or whether the American Psychological Association was involved or not. So,
I think these two books marry together really well, because so much of what Professor Pfander was saying about the unfolding of how the law has approached the problems about which his book, at which his book is directed, is the same exact story that my book tells in a related context. So, for example, this idea that there was a fairly straightforward, well-accepted, and you might call it formalist or strict approach to the protection of individual rights that were fairly well settled at the founding in the habeas context, even in wartime, is the basic story that the book tells, and that we see a story of decline. Mine has a particular flashpoint, and I'll talk about that, or erosion, if you will, of something that was well accepted well into portions of American history in my case, to the point that now we see a very similar approach, that we have the modern court looking at habeas corpus in wartime, trying to balance things in a way that has the court at the center of everything, which on the one hand many people have championed and at first blush seems like a good thing, but when you dig under the surface, what you realize is that the well-settled rights are now off the table and no longer receiving the traditional protection, historical protection that they received. And you have the court in the business, and this is the same thing that Professor Pfander was discussing, of doing the balancing itself about our priorities in times of war and how national security concerns should fall into the calculus, whereas the story that my book tells is going back well through, certainly at the founding and well through Reconstruction. The Constitution envisioned that those decisions, those trade-offs would be made by the political branches. So it's a very similar story, again in a related context. So to bring it back, also, and to start in the same place with the 4th of July coming here so soon, to think about the founding and think about what was it that the Americans were trying to achieve in breaking away for independence. Well, we all know so much of that story. But it turns out a part of that story is tied to habeas corpus. In England, leading up to the founding, there had been a robust common law writ of habeas corpus. It is the writ with which we are all familiar. It's what we're indoctrinated to understand about habeas corpus. And we tend to think of it largely as a procedural mechanism. So the story is a court on a petition for a writ of habeas corpus. I started to say certiorari. I've been so fixated on the Supreme Court in the last week. On a petition for a writ of habeas corpus, a court takes up a case involving someone who's in jail and asks the jailer to explain why that person is in prison. Well, that's just a procedure. The only thing that's going to be meaningful in terms of limiting the executive or protecting individual rights is going to be the content of the law that governs what kind of answer suffices to sustain the detention, right? And so in the early 1600s, the early 17th century, the king would throw people in the Tower of London, like Charles I did regularly, if they didn't loan him money, if he didn't like them, if they were opposing him in Parliament. And then you would see a writ of habeas corpus be brought to the Court of King's Bench, as in the famous case of the 5 Knights, and the crown would be defended by the Attorney General, in that case Heath, and he would say the king has ordered by his special command that they be put in the Tower of London. That's due process. That satisfies Magna Carta, because the king is the font of all law. That's the law of the land in action. And you see the Court of King's Bench sort of step back and say, as they did in that case to the prisoners, if you want to get out, I'm sure if you go to the king and beg for mercy, he will release you. And that's the remedy they get, which is to say the court does nothing. And again, that highlights how the process is just that, unless there's something backing it up. And the story of English habeas jurisprudence that plays out over that century culminates after decades of development, driven in the wake of the case of the 5 Knights by John Selden and Cook, ultimately in the English Habeas Corpus Act of 1679. So one of the key theses of my book is that that act is actually crucial to understanding both the course of English habeas jurisprudence as it unfolds, but very much so also American habeas jurisprudence and American constitutional habeas jurisprudence. as we get into the founding and well through much of our history. And that act is important because it's wrapped up with the rise of parliamentary supremacy. And it's wrapped up with this idea that Parliament is going to take power from the Crown, and it's going to control the law of detention. Not always for the better. The Bill of Attainder is going to survive well through this period and be used to circumvent the Habeas Corpus Act. We're going to get to suspension shortly as another way around it. But the Act is really powerful as a check on the executive because, among other things, in its 7th section, it says the executive can no longer detain outside the criminal process. So for anyone who can claim the protection of the Act, they get a timely trial on specific charges within a matter of months, between 1 and 2 court terms. That's 3 to 6 months in the Court of King's Bench, or they must be released. And if the judges, who at this time are still, this is evolving and they're becoming more independent, but they still are under the control of the Crown, if they disobey this, they can be fined, they can be sanctioned. So Parliament writes a very powerful check on both the executive and his courts. And it works. It's so effective, in fact, that the courts are letting people out of prison when the Crown can't back it up with a criminal prosecution and ultimate conviction, that 10 years later, in the wake of the Glorious Revolution, when William has taken the throne and there's huge instability, and he believes, probably correctly, that people are all over the place plotting his demise and the reinstatement of the Stuart line, he goes to Parliament and says, I need to be able to arrest on suspicion alone, and I won't be able to back it up with prosecution, but I gotta be able to arrest these people and put them away so that I can solidify my reign and my control here and keep the Stuarts at bay. So Parliament invents suspension. And the whole point of suspension is to set aside the restrictions in the Habeas Corpus Act, and particularly Section 7, for a brief period of time. And the early suspensions are 1 month in length. They're extremely brief because Parliament realizes this is a really, really big deal. This is a huge infringement of individual liberty. After all this, after this amazingly important statute that we've written that is a check on executive authority, we are now giving, in effect, the executive almost a blank check to circumvent it for limited periods. So we need to curtail that. That's the model that is established and that controls going into the American Revolution. But what we see, apropos of the timing of our talk today, is that in the founding period, the Crown does not allow the colonies to adopt the English Habeas Corpus Act for themselves, and in fact routinely vetoes efforts on the part of the colonies to do this. And the Crown takes the position that the Act does not apply in the colonies. Now this does not sit well with the Americans, because they're reading Blackstone to glorify this Act as nothing short of a second Magna Carta. And they're reading Henry Kerr's treatise that replicates it verbatim and calls it on par with Magna Carta and the English Bill of Rights and the Trial of Treasons Act as the most important protector of English civil liberties ever to have been invented. And they're reading other treatises as well to glorify it, but they don't get its protections, and they don't get the jury trial right, and they don't get a lot of other things. And so there's a lot of founding era evidence that shows the American colonists complaining not just about the jury trial right, not just about taxation without representation, but also about the denial of the Act's protection. And so that becomes a part of the larger movement for more rights and for ultimately independence. That sets up the founding period in the Revolution, during which the Americans learn all about how suspension works, because the Crown, faced with thousands of American prisoners coming to English soil, where in the view of the British, they are British subjects who are traitors and owe allegiance, which means, as Lord Mansfield advises the administration, they can claim the protection of English law when they're on English soil, which means in turn, if they are being held outside the criminal process, they can claim the protections of the English Habeas Corpus Act. And a couple of prominent cases that I detail in the book involve just that, Americans being detained in various ways, hiring attorneys or being represented by attorneys with ties to the American cause who invoke the Act's protections to try and get them their freedom. History had taught it to do so. they enact a suspension. And it governs all Americans who are brought to English soil during the war. And ultimately, some 3,000 are held in various prisons during the war without charges because, as Lord North in introducing it says, we can't prosecute them, or perhaps we don't want to prosecute them. They know that in many cases it will be very controversial. And we can't let them go. And Lord North says, in introducing the measure in Parliament, we need to be able to hold them like other prisoners of war. So suspension is viewed as something like a tool for holding prisoners in a capacity akin to prisoner of war. And it applies to those who can claim the protection of the domestic law. They're different, for example, in the Revolution than the French soldiers who are captured, who are governed by the law of nations and who can be held as prisoners of war. And in fact, the American prisoners held in England during this period were treated differently than the French prisoners. They were given lesser rations. They were treated in a more punitive manner. The reward for capturing one of them was higher because it was a bigger deal. They were traitors. So they were treated under a different legal framework. All that sets the backdrop for the American Constitution, independence, and the Constitutional Convention, and the drafting of the suspension clause. And one of many things that my book tries to do is really capture, based on the limited evidence that we have, what the founding generation thought of this model, how well they knew it, and how much it informed the suspension clause. And the answer, I think, based on what I take to be overwhelming evidence, is that this was, in fact, the model, the foundation for the suspension clause. And the idea was we were going to constitutionalize this model, constitutionalize the protections associated with the privilege, and particularly the Act, which is mentioned repeatedly in the convention debates and in a lot of the contemporary literature. And we were going to constitutionalize limitations on when suspension could take place, because the Americans knew all too well what a big deal suspension was, and they were attuned to the potential for its abuse. So a lot of people in the convention worried that it would be used, for example, to target political enemies, among other things. So you can only suspend under the Constitution in cases of rebellion or invasion. Now, all of this sets the groundwork, and to fast forward quite at rapid speed, for the Civil War, where Abraham Lincoln, as I write in the book, I believe mistakenly claims the power to suspend on his own. That doesn't marry with the whole English history, which was about taking the power over these decisions from the executive. And so I think it's problematic, and I write that in the book. But Lincoln did appreciate very acutely that he needed the imprimatur of a suspension to hold people outside the criminal process, including Confederate soldiers, who he viewed, like the British had viewed the Americans during the Revolution, as owing allegiance. And that meant, on Lincoln's view, and to be clear, he was not fully consistent across all categories about this, but he was in this category, it meant they could claim the protection of the suspension clause. And that's why he was so desirous of suspending early in the war, so that he could hold outside of the criminal process and protect the Union and its interests as the war unfolded. Congress ultimately passes a suspension 2 years into the war and takes the same approach. They believe they need the imprimatur of a suspension to hold even Confederate soldiers outside the legal process, outside the criminal process, that is. So that, in short, is this model that's very well established. And the role of the courts is, if you go into court and there isn't a suspension and you're not being held by civilian authorities and you can claim the protection of the Constitution and you're not being prosecuted, you will be discharged. That was the understanding that everyone operated under through this whole period. And where it breaks down, interestingly enough, is in World War II with the internment of Japanese Americans. And so my book is a story of a similar, as I said at the outset, erosion of a legal framework that was very well settled, akin to the story that Professor Pfander's book is telling. But it's also a story of how it can happen in one powerful flashpoint in American history, and how, in my particular case that I'm detailing in the book, in World War II, every branch has a role in that erosion. So the administration, the Roosevelt administration, interestingly enough, was told when this was first proposed by the Attorney General and by the Secretary of War, among many others, you cannot do this with respect to the citizens. You cannot hold American citizens, no matter what they look like, outside the criminal process without a suspension. That's unconstitutional. Attorney General Biddle said repeatedly. But it didn't matter. The policies rolled out all the same. Then you have Congress. Congress never takes up the issue at all. All they do is write a law and enact a law that provides criminal sanctions for violations of the many military regulations that are implemented in the executive branch, which ultimately lead to the internment of over 70,000 American citizens of Japanese ancestry. And then finally, as the cases make their way into the courts, the one case that provides a clean and direct vehicle for challenging the internment, not Korematsu, not Hirabayashi, not Yasui, it's Ex parte Indo. That's the one case that directly challenges the internment. There, the court, faced with powerful suspension clause arguments, invoking Milligan from the Civil War period and other important precedents, the court does not decide the case. It says, we won't decide the constitutional issues because we don't want to stir that pot. That's the phrase Justice Douglas uses. Instead, the government had conceded that Ms. Indo was loyal and in fact had offered her release, but she stayed in the camps for 2 years to keep her case alive, knowing it was the only one that was a clean challenge to the internment. And she herself is a fascinating story, and I'd welcome the chance to talk more about her if you're interested. But in all events, because the government had conceded she was loyal, the court ultimately says, we read the military regulations to require release for anyone who's concededly loyal, and that's all we need to do. She wins her case. So the court doesn't establish any meaningful precedent for doing that. What is significant about Indo is it is a victory for her in the small sense, right? She's won her case and she wins her release, but she'd already been offered release. That's not what she wanted. But she does succeed in the larger sense of, because this case, knowing it will be portrayed as a loss, the Supreme Court communicates to the White House, you're going to lose Indo. And then they hold it up. And the White House then gets ahead of the decision and announces that they will finally close the camps. And the decision comes down the next day. So it is an on-the-ground, genuine victory for her, but it's a case study throughout this period in how the erosion of rights that were otherwise well settled can happen. And the lesson, I think, as it plays out, has many facets to it. So first of all, we see that shift in the law there then lay the groundwork for the War on Terror. And the Hamdi decision in particular, where the Supreme Court says, over a dissent written by Justice Scalia joined by Justice Stevens, two people you don't normally see joined together, we are going to ignore all this history in their dissent, and we're going to look at the situation, and we're going to, coming back to what I said in the beginning, we're going to provide process for an American citizen who's being held, labeled as an enemy combatant, and he can try and argue that he's not an enemy combatant, and the government can try and argue that he is, but we're not going to say anything about whether he can actually be held as an enemy combatant beyond saying, yes, actually he can. And this is important because we need to balance the interests that are at stake, the national security interests and the individual liberty interests. And all of that is a dramatic break from the founding in this model, which put those decisions in the political branches and then limited when they could be invoked. And further, now we have this precedent solidified in Hamdi, which is really grounded in the Japanese-American internment, that the government can do this. And the other lesson, I think, of the World War II period in establishing, sort of getting us off the rails here and changing course in this area of jurisprudence, is that the responsibility, in my view, and I write this in the book, falls on every branch of government, all of whom were participants in this shift away from what had been a well-established body of jurisprudence and well-established norms that were at the heart of what the suspension clause was supposed to do. So that's what the book is about, and as I said, I think the themes are very much akin to those that are raised in Jim's book.
We could stop for a few questions and then maybe spend a little bit of time talking about where the doctrine might go in the future. Yeah, please.
Yeah. Amanda has told us, in essence, how things went off the rails in the habeas area. You said, it used to be formalist, and now it isn't, but you haven't said how we got from one to the other.
Okay, so a very good question. And the way we got there is a combination of the Erie Doctrine and the statutorification, if you will, of government remedies. So Erie comes along and it says that common law rights of action are governed by state law. And Bivens, the decision in 1971, is essentially a response to that, a reclaiming by creating a federal common law right of action, reclaiming a kind of judicial control of the ability to provide remedies for violation of tort-based kinds of rights, false imprisonment, trespass kinds of claims, batteries, assaults, and that sort of thing. Then Congress gets in the game and it adopts the Federal Tort Claims Act, providing for intentional torts to be adjudicated in suits against the United States, and a few years later adopts something called the Westfall Act. And the Westfall Act essentially eliminates all common law claims brought against federal officials. So it sets up a world in which the only basis on which you can bring a tort claim for damages based on federal official conduct is under the Federal Tort Claims Act, a federal statute, or a Bivens claim based on the Constitution. Those are the two options available. And the Federal Tort Claims Act does not apply to cases involving the military. There's an exception for combatant activities. It doesn't apply to events that take place overseas. It only applies to events that occur in the United States. So if the injury occurs outside the United States, the FTCA does not apply to it. So Congress, and I would echo Professor Tyler's observation, it takes all three branches really to effect a change, even though every sort of step in the, or link in the chain towards change may be articulated by a particular branch. But the Supreme Court starts down the road of creating rights to sue for constitutional torts. Congress responds by supporting that right to sue, by cutting off access to common law rights of action in state court. So that's sort of been eliminated. If the FTCA is no longer available, then there's no tort-based claim to bring against officers of the federal government, and the only option you have is a Bivens option, and it's that option that the court has systematically sort of curtailed over the course of the last 25 years or so. So that's a very brief sort of.
And the FTCA includes a lot of immunities for policy-based.
Oh yes, of course, the discretionary function exception, the Ferris Doctrine exception for events that occur in the military, a whole series of exceptions. So
for our purposes, if you don't have a Bivens claim, you're shit out of luck.
that is basically the story, right? Absolutely right. And that's true in a case like the Hernandez cross-border shooting case, the case of the Border Patrol officer who apprehended an individual on the Texas side of the border, and then feeling threatened somehow by a 15-year-old teenager on the other side of the border, shot and killed him. And that shooting has led to requests by Mexico for the extradition of the individual for the so that Mexican civil and criminal process could go forward against him. The U.S. government has resisted requests for extradition. And so if you think about what sorts of remedies might be available to the family of the teenager, it's very hard to identify any remedy other than a Bivens action. The common law suit for damages is not available. The FTCA claim, the Federal Tort Claims Act claim, is unavailable. Even if you were able to pursue a claim successfully against the officer in the courts of Mexico and you were able to obtain a judgment in Mexico, you couldn't enforce that judgment against the assets of the officer in the United States because that would also violate the Federal Tort Claims Act. So it is Bivens or nothing in those kinds of situations, and I think that's something that has slipped from, in some ways, the awareness of the Supreme Court, or maybe the Supreme Court thinks that at this stage it's really up to Congress to write a statute that authorizes claims of this kind, that we as a court are just not in a position to provide redress.
I was wondering if you both could comment on what you think the roles of different judicial philosophy plays in terms of judicial deference to the executive in this manner, and not necessarily along the lines of conservative or liberal, but even just thinking about like what is the proper role of the judiciary. Because as you were talking about the role of habeas corpus, originally I was thinking, well, maybe someone more to the left might see it this way, but the analysis kind of sounds very similar to how Scalia approached DC versus Heller. So I was wondering how you thought about like the role that judicial philosophy plays in these decisions.
Yeah, so I'll take that. I think both of our books highlight a really interesting phenomenon, which is that if you do the work, if you do the legal history work and you uncover how we thought about these problems, which are not new problems. Most of our legal problems, at least at certain levels of generality, are not new. The question of how the executive navigates the law in times of war with respect to decisions about whom he can detain and under what circumstances, this is not a new question. This is a question that has come up for hundreds of years. And the same is true about, at larger levels, what happens when the government injures people or takes property or wrongs individuals through its officers. These are questions that have come up repeatedly over time. So if you're willing to do the work and uncover the history, and as we both have done, and tell a story about it, we're both telling a story that's fairly well settled at the founding and well into. It's not even just, if you want to connect back to your question, an originalist story that stops in 1789. It's a story that unfolds in many decades that follow and remains largely consistent for some period of time. You would think that an originalist would be really interested in that story. And what I think we find, I don't want to overstep here, but I think my co-panelists will agree with me, is that in both of our areas about which we're writing, we don't see that. With one exception in my context, which is Justice Scalia in the Hamdi case. He writes a dissent that hits some of the highlights about which my book is written, and he wrote it obviously before my book. What I've tried to do is go back and go quite a bit deeper into that history and talk about other periods that he did not discuss. But at the end of the day, I wind up in the same place as he did. What's interesting to me is that he's joined by Justice Stevens in that case, but you take Justice Thomas, and I think this is emblematic of the larger point I'd want to make in response to your question. Justice Thomas is an avowed originalist, and he writes a separate opinion in Hamdi, on which he says, among other things, if Scalia's right, he doesn't question the history at all, but he says, if Scalia is right, this is really problematic, because it means in times like now, post 9/11, Congress has very limited choices about how to deal with people like Hamdi, who are believed to be bad guys. And in fact, he's pushing them to either suspend, and we don't even know if they could suspend, and that's a problem, Justice Thomas says in his opinion. And whatever you think of the various schools, a true originalist should not write an opinion like that, because it's a policy opinion. It's an opinion that says, this framework, if that's right, is problematic. And we should give Congress the leeway and the executive the leeway to work outside of it. That's not an originalist opinion, whatever it is. And so I think that's a really interesting study of how we see people shifting their positions when it gets to national security. And I suspect that you would tell a related story or a similar story.
Yeah, the story is very much the same for me. One of the things that strikes me about the early history that I recount in the book is how justices sort of across the spectrum were all committed to the same conception of government accountability. So you get decisions by Chief Justice Marshall, you get appointed by the Federalists, obviously, or conservatives as we would understand them today. You get decisions by Justice Story, appointed by a Democrat, but perhaps a bit more conservative or Federalist in his inclinations. You get decisions by Chief Justice Taney, appointed by the most Democrat of Democrats, President Andrew Jackson. And so all of the justices from those various walks of life were committed to the same conception of government accountability that I sort of recount in the book, this sort of strict, formalistic, rigid, whatever you want to call it, notion. And we see today that the conception of government accountability that both Amanda and I, Professor Tyler and I, argue for in our respective books has become politicized in some way. And that's really one of the puzzling things to me. So why is it that these doctrines that were once well accepted, both habeas and the suability of government officers for damages, so well accepted, so sort of embedded in the culture, have now become kind of sort of philosophical or political flashpoints? And that's a puzzle to me. I do see some glimmer of a basis for hope, and it's a very small one. So you do have Justice Scalia arguing for a kind of return to an approach to habeas that was consistent with the history that Professor Tyler has uncovered. And his opinions have a fair amount of staying power, as you might reflect on Morrison versus Olson and his separate opinion in that case. Justice Thomas has staked out a kind of separate position on qualified immunity that corresponds to a position on qualified immunity that some conservatively inclined professors have become to embrace, in particular Professor Bode, written an article arguing that qualified immunity is unlawful, and that kind of call has now been taken up by Justice Thomas. And I've just been invited, oddly enough, to present on the Bivens doctrine to the Institute for Justice. We don't think of the Institute for Justice as necessarily championing liberal causes, but we do think of them as championing individual rights and trying to secure them through some kind of judicial enforcement. And they've been working the injunctive declaratory relief side of the street for a long time, and now they've decided that they want to get in the damages game. And if you see a group like that take an interest in damages, maybe it doesn't seem like it's freighted with the same kind of partisan valence that sometimes these opinions seem to convey. So that maybe is a small glimmer, but maybe not much.
So I have
No, go ahead.
this is sort of an ignorant historical question. How did the prisoners end up in Australia? I don't remember. They was from England somehow. I was told that all the prisoners ended up in Australia, but when and who?
So I can't tell you the whole story, but what I can tell you in the context of my book is that it was very common for prisoners during and following wars in England and Britain in their history to be sent away. So they would be captured in wartime. Often there would be a suspension. This was very common during the Jacobite Rebellion. So you'd have a suspension in place. And interestingly enough, sometimes even within the context of a suspension, prisoners would be tried if it was easy. So in the context of the Jacobites, because they could prove treason very easily, and they thought it was more effective in waging that war to execute them, they would try them by the dozens and execute them immediately to try and put the fear into fomenting further rebellion in Scotland. But they would also put prisoners on ships and send them to the colonies or force them into service in the Royal Navy. And so I suspect that the story of Australia is wrapped up in this larger practice, though I do not confess to be an expert.
So there was transportation of prisoners too.
Yeah.
Folks who were
to the Americas.
right, yeah,
To the
and to
Americas.
Australia as well. It's a
Yeah.
prison colony in its origins, obviously.
Yeah,
Australia is.
And that was pursuant to criminal sentence, was it not?
Right, yeah, it was.
I think in that case, yes.
Getting back to Bivens through the lens of Hernandez, Hernandez and its attending cases like Schwartz effectively presented several questions. Number one, whether the Fourth Amendment applies extraterritorially. Two, the qualified immunity, and then three, whether there was remedy. So in Hernandez, the court sidestepped the Fourth Amendment question, although we can kind of gather from their performance during oral arguments that it was almost as if they didn't need to touch on that because it was obvious that it does apply. And Schwartz also said that and took care of the qualified immunity question. So now it all comes down to whether there's a remedy, and in the larger question of does this give government agents an effective blank check to violate
constitutional rights because there is effectively no remedy or no accountability. And as we know, the Hernandez decision basically said, well, the fact that this is an extraterritorial application question is a new special factor, counsel's hesitation, and Ziegler says that's a no. Now we have this new petition that is, I think, making a pretty decent argument against the fact that this really isn't a new special factor. But the thing that I'm concerned about here is, given the political environment and what's happening now on the US-Mexican border, which is undoubtedly going to spawn new civil rights litigation as far as governmental abuses of power. Where do you see this Bivens or some sort of remedy argument going? Because now more than ever it is becoming a political question, and I'm afraid that either the Supreme Court, now with its potential new makeup, is going to either really shut down Bivens, or even worse, Congress is going to come up with some crazy solution that effectively shuts down any kind of remedy. So where do you see this going from now to the near future?
So the question is a good one, I think, because it highlights the many different ways one can lose a Bivens action. The refusal to recognize a right to sue, the doctrine of qualified immunity, questions about the extraterritorial application of law. These are all questions that I tackle at perhaps excessive length in the book. So I won't give you the full blow-by-blow, but there are stories to tell about each aspect of the doctrine. There are ways in which the court could walk this doctrine back, both on the qualified immunity phase of the litigation, on the right of action phase of the litigation, and with respect to extraterritoriality, because here's an interesting and little-known fact, and that is that at common law, extraterritorial application was quite the norm. So in a case called Mitchell versus Harmony, there's this fellow who's like traveling with the United States Army during the Mexico-American War, and he's in Chihuahua, and his property is taken and destroyed in the course of that conflict, and it's attributable to the actions of a U.S. general. The lawsuit was brought in the courts of New York against that general who was served with process in New York, and the court deliberately adopted the transitory tort doctrine and upheld an imposition of liability on this general to the tune of $100,000 for the loss of the property in question. So a very revealing expression, again, very much drawn from English common law, the notion that the law travels with the officer of the crown, the officer of the government, and is applicable wherever the government official takes action. I think that still should be the rule governing extraterritoriality. If a government official happens to be controlling activity in Guantanamo Bay, it seems to me clear that U.S. law has to control the actions of that government official in Guantanamo Bay. There's no conflict of law that would occasion the need for a choice or the need to restrict the extraterritorial application of U.S. law. So it seems to me an easy case for the application of U.S. law, and it's not inconsistent with some of the other Fourth Amendment decisions that the Supreme Court has handed down.
I think Hernandez and Schwartz did a good job of kind of peeling that onion, and so the extraterritorial argument kind of fell away, the community argument kind of fell away for the government,
right.
And it's like they put all their eggs in the remedy basket because they really had nothing to come back on those other two issues. And so, like I said, with the political upheaval on the border now, and we know this is going to spawn more litigation against federal agents, focusing on Bivens, where do we go from here? I mean, we got this new petition, but where do you see this going?
Well, it's very hard for me to see how a lower court is going to conclude that this is not a new context within the meaning of Ziegler versus Abbasi, the decision from 2017, because Ziegler seems to take the position that almost everything will constitute a new context. unless it falls within the four corners of the Fourth Amendment. So these are some established contexts, or Eighth Amendment prison kinds of claims. But even the prison context in Ziegler itself, the court said, this is a different kind of case in Ziegler from the case that we decided earlier, Carlson and Green. And since it's not on all fours with Carlson, it's a new context, and the special factors analysis has to apply even to a prison condition claim, which had previously been understood to sort of be within the four corners of established Bivens law. And if that narrow approach to new contexts is the message that Ziegler intends to send, and I think it is, then we're going to have special factors analyses applying to virtually everything that's not on all fours with established Supreme Court decisional law. And if that's true, then the argument that Hernandez is a new context is at least certainly available to the government, if not compelled, as would many other cross-border issues be. Because the context in which Bivens cases have been decided has been entirely domestic so far, right? So Bivens was himself a citizen of the United States whose house was searched in the United States. Carlson and Green is an Indiana prison case. So we haven't had the Supreme Court apply the Bivens doctrine to anything that even touches a border.
So do you think the solution is to re-argue the four corners of the Fourth Amendment, which your excessive academic research and my minor academic research of my paper, which you helped me with, thank you very much, kind of goes back and says, well, wait a minute, this always was a within the Fourth Amendment.
Yeah, so you can do that, but you still have, as you recognize, the question of whether there's a Bivens right to sue or not. And my take, I mean, you can be more or less depressed about the Ziegler and Abbasi decision, but one way to read it is to say the ball's in Congress's court now. We got these two pockets of Bivens law that we're going to do. We're going to do Eighth Amendment prison claims. We're going to do Fourth Amendment law enforcement claims in the United States, and everything else is for Congress to decide. And if we live in that world, then deference on the border seems to be a likely consequence of it. So, Peter DeCola.
First, I don't want to go without saying these sound like two amazing pieces of scholarship, and thanks, this has been a fascinating panel. My question, I think, is inspired most by Professor Tyler's comments. I'm wondering what part of what's going on now around year 17 of the war in Afghanistan and everywhere else, but under the same authorization as Jerry Forrest. And I'm wondering, so it's a 17-year emergency. It's not 1 month. I'm wondering, there were long wars before, though, in English history. Like, but maybe not since the Habeas Act. But I'm just wondering, like, is there any precedent for clawing back, or what is it about our time where both political parties basically have said, we really like these powers. Eric Holder came to Northwestern a few years ago and said, I'm good with vaporizing American citizens from space without due process. That's what I'm going to use my speech to talk about. In retrospect, maybe we can talk about something else now, given where we are. But, everyone has signed on to that, right? And so I'm just wondering, like, is there any precedent for getting back from that kind of unfortunate consensus where both parties are like, well, this is going to be great. When we get our hands on the executive, we'll be able to do whatever we want.
In terms of the historical precedents, I'm taking the two aspects of what I've written about, two aspects of the story that I try to chronicle in the book. As I'm speaking, I'm going to continue to think about whether there are more examples, but the primary two flashpoints that come to mind are the early history of the Habeas Corpus Act, which was the culmination of many decades of struggle on the part of Parliament to take control of this law from the executive, particularly out of concern about how it was wielded, including especially at political enemies. And so when you trace that background and you tell that story, you then see, with the invention of suspension, that it's very controversial. And people are complaining, knowledgeable people who were part of driving through successfully the English Habeas Corpus Act are on board with the first suspension, and then they start quickly to become critics and fall by the wayside. And so in the early post-glorious revolution suspensions, what you see is, for the first one, a lot of support. And then when you get into extensions and re-upping it, you start to see really robust debate and people saying, wait a second, we've invented something that's very dangerous and we need to be very, very careful about it. And the second major point of this story, which picks up and tells precisely the same story, is the Constitutional Convention and the Ratification Debates, where this exact same conversation is unfolding. And what's different, and in my view, and I stake this out in the book, significant about this second part of the story is that acutely aware of these concerns and how English history and British history had played out with respect to suspension, and acutely aware of some of the shortfalls of not having a true separation of powers, the men who wrote our Constitution, I'm used to saying men and women, but of course in this case it's men, who wrote our Constitution, included provisions to very carefully circumscribe when suspension could take place. And I think they did it in part aware of the fact that not only could the tool be wielded for improper purposes, so Luther Martin repeatedly complained that this is a huge power that can be used to silence political foes, for example, and many others made this argument, but they were also aware of the potential for it to drag out, to be expanded, for emergency to last forever, as your question highlights. And I think that is why they include limitations, very strict limitations, on when suspension can be invoked. And that's wrapped up with the fact that a number of states voted against recognizing a suspension authority at all. So the suspension clause reads, the privilege of the writ of habeas corpus shall not be suspended in cases, where in cases of rebellion or invasion, the public safety may require it. A number of states said stop at shall not be suspended, period. Right? And so it was by one vote that the back half of the clause gets sent through. And that's significant. That shows you just how suspicious they were of this power. And then when you dive deep into the ratification debates, which is where you find most of the discussion of the suspension clause, because it gets very little discussion at the convention, you find people saying these are known and certain circumstances, rebellion and invasion, a proposition with which everyone today does not agree. But there's a lot of support for this proposition in the founding debates, and you have a number of people go on record saying, and if they don't exist, judges will say the suspension is invalid. So there's also evidence that the founding generation believed the judiciary would provide the backstop to check this dramatic power. And I think that is the most important component to this whole story of how we apply it today. Because if you look today and you look at a war on terrorism that is in, as you say, its 17th year with no end in sight, something we could have predicted in 2004 when Hamdi was in front of the court, you need to somehow connect this modern story with these larger questions about the judicial role that have been a part of our constitutional discussion from the founding and were very fervently discussed and debated and aired during the founding. And it's really hard to stand up what the plurality did in Hamdi, saying there's no bar to holding a citizen as an enemy combatant, and we're going to balance national security against individual liberty. And they even go further in the O'Connor opinion to say, and maybe even a military tribunal can do this, citizenship doesn't actually matter, is the sum total of the decision. How do you stand that up to the story I'm telling about the founding and the vision that they had for this independent judiciary that, to borrow from Hamilton, was supposed to stand between the people and the political branches? It's a really different vision for the judiciary. And that's why I personally find it so baffling that so many of the commentators who write about Hamdi look at it as this great decision about the judicial role, because they've rebuked, this was the account of many, they've rebuked the Bush administration. The only rebuking they did was to not give them a complete hall pass to detain American citizens on their own without any review as enemy combatants. A breathtaking assertion of power that was made. But they don't really preserve much of a role for themselves. I think mainly the role they preserve is to be a party to the larger power that they disclaim granting the executive. And that's really hard to square with this vision of the judiciary from the founding. So it ties in again to these larger themes.
I can't resist just adding a quick note, and that is that Professor Tyler's book is so good that it's going to be very persuasive across the aisle. And that is, I think, a basis for some hope. That is to say, framing the arguments as she has done, I think, is going to be very powerful, and it's going to reach judges on both sides of the aisle, and I think that maybe is a basis for some hope. But I agree with you that there's not much. I'm going to defer to my.
Do we have time for one more question? Yeah, why don't we do one more question?
Sure, let's do it.
Go ahead.
Please.
If today American president invoked suspension without proper just cause and Congress did nothing to push back, who would have standing to challenge the invocation of suspension?
So that is a great question, and to my horror, I don't think it's no longer an abstract academic question. When I started writing about the suspension clause now over a decade ago, I've been writing about it for a long time. It's probably time to move on. I spun out a hypothetical in one of my early articles about a president suspending to address the invasion of illegal immigrants. And I no longer think it's just a funny hypothetical. And I fear that someone might read that and get an idea, which raises then a host of questions, the main one of which is yours. What could be done in response? Congress is unlikely to act, at least this Congress, I think it's fair to say, which leaves the judiciary. So the judiciary has a mixed record on these kinds of cases. The primary precedent on point, if the president were to get out ahead of Congress and suspend, is Ex parte Merriman, in which Chief Justice Taney went effectively to battle with President Lincoln over the question whether the president has the authority to suspend. And whatever you think of Chief Justice Taney, that opinion is exceptionally well written. And it's exceptionally well written because Chief Justice Taney knew his history. And so a good portion of the early part of the opinion is about John Selden and John Selden's efforts in the case of the 5 Knights to argue that the executive does not have freestanding authority to detain on his word. And then Taney goes on to chronicle the very story I've told you about the developments leading up to the English Habeas Corpus Act and how the act is the culmination of all of Selden's arguments in the case of the 5 Knights and later in Parliament, pushing the Petition of Right and other things for many decades. So Taney knew this history, and he asks at one point in a very poignant quote, am I to believe that the American people, in writing their Constitution, have chosen to give more authority to the President of the United States than the English and the British have thought fit to give to their king or queen? Unlikely, he suggests. So I think that's right, and I think that's a very strong precedent. But then there are 2 major questions that are raised. One, would this court follow through and respect and enforce that precedent? I don't know. I don't even know what the court's going to look like in a year, 6 months for that matter. And 2, who could be the litigant? Because of everything that we've been discussing about extraterritoriality, and also the reluctance in many areas of jurisprudence, including in habeas, both historically and in current times, to treat non-citizens and citizens the same way, with a notable and important exception of recent vintage. It's unclear whether a court would accord a non-citizen who crossed the border the appropriate standing to challenge such an exercise. But the big exception, and I think the big precedent that would support doing that, is Boumediene versus Bush, which effectively treated litigants for purposes of the suspension clause on the same footing, whether they were citizens like Yasser Hamdi held on American soil or detainees with no prior ties to the United States held at Guantanamo Bay. They were accorded the same effective standing under the suspension clause. And so that precedent would seem very strongly to support giving standing in that circumstance. But we'll see. I hope that my hypothetical, let me be very clear, I really hope that my hypothetical does not come to pass.
Well, Trump doesn't read, but unfortunately he employs people who do.
And it's up to you.
Hello, everyone. Thank you all for coming. Please give another round of applause.